So the NBA and Major League Baseball have had to postpone games because of the case of Jacob Blake. So in this video, we're going to look at the facts of the shooting of Jacob Blake. Now, my handle is Nate the Lawyer, and welcome to my YouTube spot. I am a former law enforcement officer, former prosecutor, and I taught at a law school for the past 2 years. Currently, I'm a private attorney, and I do private practice. As a black law enforcement officer, as a former black prosecutor, and as a black attorney, I think it's important to look at both the law and the facts of any incident before you pass judgment. The most important thing about my videos is that you are the judge. You get to decide whether things are justified or unjustified. And we do that by looking at the facts and the law dispassionately. Now, we do have to understand the cultural context of the times we're living in. Racism plays a factor in some of these things, but not always. And we have to understand when race does play a factor and when it does not, because those are two important questions we have to answer. So we're going to try to see if we can answer those questions today with the case of Robert Blake. But to do that, I'm going to need more of your attention than I usually do. I'm going to need to both teach you law, show you examples, and then apply the law to Mr. Blake's situation. That's the only way we're going to get a clear understanding of what happened. Now, before we get started with our analysis, if you like what you hear, consider subscribing to the channel and consider picking up a channel membership or even becoming a Patreon. The reason why this is important because this video is going to be demonetized. There are too many incidents of police shootings that I have to show you so you can get a real firm grasp of the principles and concepts that I'm about to show you. And I can only do that with viewer support. So I'd appreciate it if you simply subscribe to the channel, grab a channel membership, or even become a Patreon. So first, with any analysis, we have to start with the law. Now, there are two cases that set out the standards for police to use force here in the United States. And those two cases are Tennessee versus Garner and Graham versus Garner. I need to take you back to a time in the United States where it was lawful for police to shoot fleeing felons in the back to apprehend them. So simply put, if you committed a felony and you were running away from the police, they would be able to shoot you in the back to apprehend you. Now, there was no distinction between violent felony and nonviolent felony. You could be killed for running away from the police. Now, this brings us to our first case, Tennessee v. Garner. Now, one of the most interesting facts about this case that most people don't know is both the suspect in this case was black, but the officer who actually shot Mr. Garner was also black. Let's talk about the facts. Two officers respond to a radio call for a burglary in progress. Two officers get to the house and they see a home with a broken window. One officer goes around back, the other one calls for backup, and the officer who goes around back sees someone in the backyard. The officer screams, "Stop!" The person jumps on the fence and begins to climb. Now, because of the way the yard was situated, the officer believed that if the suspect got over the fence, he would get away. So at that point in time, the officer made a judgment call to pull out his service revolver and stop what he perceived as a fleeing felon from getting away. He shoots one shot toward Mr. Garner, hitting him in the back of the head, and Mr. Garner is dead. Now, under Tennessee law, this shooting was justified. Mr. Garner has just committed a felony, a burglary. He was fleeing from the police, and the police shot him to apprehend him, unfortunately killing him, but that was the law. That was the policy. Well, Mr. Garner's family didn't believe that should be the policy, didn't believe the police should summarily execute people in the street. So they sued in federal court, asking the court to find these laws that allowed police to just shoot people summarily in the back for nonviolent crimes unconstitutional. And the Supreme Court found it to be unconstitutional in the landmark case Tennessee v. Garner. Every cop who's on the streets knows about the landmark case Tennessee v. Garner. When I trained police at the police academy, we explained to them the principles of Tennessee v. Garner. If you're a law enforcement officer now and you go back to your academy, ask those professionals about Tennessee v. Garner. It is a seminal case in law enforcement. The court reasoned that the Fourth Amendment prohibits the use of deadly physical force unless it is necessary to prevent escape of a fleeing felon and this "and" is very important, the officer has probable cause to believe that the suspect poses a significant threat of violence to the officer or to the community. Now, probable cause is a low standard. It's not beyond a reasonable doubt, but it allows an officer to make a judgment call based on the facts that they have in front of them, whether this person is a significant threat to the officer or to others in the community. Now, what does this actually mean? Well, in practice, it means that police can't shoot fleeing felons in the back unless they pose a significant threat of violence to the officer or to the community. So we're going to call this our serious threat question. Now, our second case determines how much force can be used if the officer determines that the suspect is a serious threat. And that's Graham v. Garner. Now, I'm not going to get into the specifics of that case, but something you need to know is the rule that comes out of that case. And the rule that comes out of this Supreme Court precedent is how every officer's use of force will be judged. This is what the Supreme Court says. A particular application of force must be judged through the perspective of a reasonable officer facing the same or similar circumstances without the benefit of 20/20 hindsight, and be based on the totality of the facts that are known to that officer at the time force was used. That force that's going to be applied to this suspect must be objectively reasonable based on that standard. Now, I know some of this stuff may not be clicking as of right now, but as we go through some examples, you'll see how the law is applied to various situations. Now, using these legal standards, let's apply them to some cases to see how they operate in the real world. Now, I need to say this before we go any further. This is not legal advice. This is just not legal advice. That's it. There may be some state laws that may differ, that may be more restrictive on some officers or not. But we're talking about the federal standard from these two cases that are used to judge police conduct throughout the country. So our first example is of Walter Scott. Now, if you haven't heard about the Walter Scott case, it was a pretty big case, but I have to give you a warning. This video is graphic. Viewer discretion is advised. Let's take a look to see what happened. Now, I've stopped the video here because we get to ask our first question, our threshold question from Tennessee v. Garner, and that is, did Mr. Scott pose a significant threat of violence to the officer or to others in the community? Now, we have to understand also the context of what we're talking about here. He has no weapon. He's just running away. Is this officer justified in using deadly physical force to apprehend Mr. Scott? That's our first question. Let's continue watching the video.
Oh shit. Shit.
Mr. Scott has been shot in the back multiple times by this officer. So the question now we must ask is from Graham v. Garner. Would a reasonable officer facing the same set of circumstances, with the same knowledge of this officer, would they have used this amount of force to apprehend this suspect? Now, prosecutors answered no. Prosecutors, both federal and state, said no. This officer failed both of these standards. First, this officer failed the Tennessee v. Garner standard because this suspect was not a serious threat to the officer or to anybody else in the community, being unarmed and just running away. This is what happens. People don't like to be arrested and run away. So this fleeing felon was not a serious threat. But then second, what about the amount of force used? Well, both federal and state prosecutors said the force used was unreasonable and violated Graham v. Garner. A reasonable officer would not have shot this man in the back. So what were the consequences? Well, this officer is now doing a life sentence. Now let's look at another example. We're in Las Vegas, and the man you're seeing on screen has just stabbed two people in random attacks. Police confronted him Now, he's armed with a knife. He's already stabbed a couple of people. And police are commanding him to drop the weapon. Let's watch what happens.
Get down! Get on the...
And now police are confronted with an issue. With the knife, who they've tried to tase, who they've tried to shoot with beanbags. He's not going down. And he's walking toward the bus stop with the person in it. So we have our first question. Did this suspect pose a significant threat of violence to the officer or to others in the community? It seems here the answer would be clearly yes. He had just stabbed 2 other people, and now he's walking to another victim or potential victim. He was armed, just stabbed 2 people, refused commands to drop the knife, and he was walking towards someone. Close proximity to him. Let's evaluate. Under Tennessee v. Garner, was this suspect a serious threat to the police or to others? I would say yes. Now let's see what happens.
Shots fired. Control 2, Paul 4. Shots fired. Subject is down. Roll medical. Come on out here. Yeah, wait.
So officers fired to stop this threat. So the question now is our second question. Would a reasonable officer facing the same set of circumstances with the same knowledge of this officer use this amount of force to stop this suspect? And it seems to be the answer is yes, because these officers were not charged. So now we're starting to get a little bit more familiar with the edges of these policies. We've seen one where someone's just running and being shot by police, and that was found to be wrong. And now we have another where you have a knife-wielding man walking towards civilians who was also shot, and we're saying the standard allows that to happen. So now we're starting to be able to refine what the law is and how the law operates in the real world. Now, for these last 2 examples, I'm going to stop it and allow you 3 seconds to come to the determination if the officer is justified to employ physical force, deadly physical force, or is not justified. So here is the dash cam video from the first case. Let's watch it together.
Most fellas gonna be the apartment. Trailer park. Hey, sir. Sir. Hey!
Now I stopped the footage here. The man's gotten out of the car. He's reaching for something in the back of the truck. The officer's screaming, "Stop, stop, put it down, put it down, put it down." At this point, is this suspect a serious threat to the officer or to other members of the community? That's a question you have to answer. Let's continue on with the tape.
Trailer park. Hey, sir. Sir. Hey! Shots fired! Shots fired! Drop the gun! Drop the gun! Oh. Johnny, let me get you in there. You okay? You okay? Yeah. What are you? I'm gonna get some off of you. Oh, it hurts. I'm not with my cane now. Johnny, I'm so sorry. Stay still. Stay still. I'll be alright. Oh, Lord, please help me. Please help me. He's going to die. He's going to die. He's going to die. You had to do what you had to do. Yeah, he pulled the key and then he went out the shotgun, man. You done what you had to do, okay? Don't worry about it. You had to do what you had to do. That son's got a little like a shotgun. He pulled it out. You done what you had to do. You done what you had to do.
So now this officer has fired 6 times at this suspect. The question is, would a reasonable officer facing the same set of circumstances with the same knowledge that this officer has had shoot this suspect? Is this officer justified in responding this way? Now, let me give you some more facts. The person who was shot was Bobby Canopy. He was 70 years old, former Vietnam veteran, living in South Carolina. Now, him and his wife were driving home. He was only hit once, with the bullet fire, and he was just picking up his cane. You can actually see it here when the officer's firing, how he puts the cane down and is actually trying to hold himself up with the cane while the officer's firing. Now, you should have your answer to whether this man was a serious threat under the standard from Tennessee v. Garner, and whether the officer's response was objectively reasonable or not. But what do you think the prosecutors in this case said? Well, they said this officer's response was reasonable and the threat perceived was reasonable. So this officer was not charged with the shooting of this unarmed 70-year-old man. Here is the police chief explaining it.
The driver of the vehicle, Bobby Dean Knight, 70, of Lincolnton, North Carolina, exited his vehicle and reached into the truck bed and raised what Deputy Knox perceived to be a long-barreled weapon.
Knox fired several shots, hitting Knight once. Turns out it was a walking cane, but the sheriff's office says in the dark, Knox believed he had to make a split-second life-or-death decision.
The situation is very unfortunate. It does appear at this time that Deputy Knox's actions were an appropriate response to what he reasonably believed to be an imminent threat to his life.
Now, this situation is a tragedy, no doubt about it, but it was lawful. So it is not the fact that the person actually has a gun, but whether the person is reaching or doing anything to make the officer, or a reasonable officer, suspect that they are reaching for a gun, they are reaching for a weapon, they are doing something that's going to harm that officer. That's what this is about. That's what it's always been about. That's why a 70-year-old white man who is in his truck with his wife can be shot. Let's transition to the two most current cases. One that you probably haven't heard about, and the second one is obviously of Jacob Blake. So this is Trayford Pellerin. He's 31, from Lafayette, Louisiana. And he was on the news a couple of days ago because he was shot by police. Now, let me give you the background. Police get a call to a gas station that there's a man who is wielding a knife. They show up, they see the man wielding a knife, and they give him verbal commands to drop the knife, drop the knife, drop the knife. Now, this man is acting erratic. He is not obeying police commands, and you will see from the tape the police do everything to try to stop this man. Let's go to the videotape.
He got a knife. That man got a knife. They gonna shoot him. No, we got to wait. We got to wait. No, but he got a knife. Get on the ground. They tasing him. He's not even doing nothing.
So I'm stopping the tape right here because I want you guys to look at something. Police wait till this suspect tries to go into the store. Now, as you can hear from the tape, you hear the witnesses saying they've tried to tase him. They're doing everything to stop, but he won't stop. He won't drop the knife. So police are now confronted with this problem. Tennessee v. Garner. Does this suspect pose a significant threat of violence to the officer or to others in the community? And remember, it has to be immediate. It can't be 2 weeks from now. Does he pose a significant threat of violence to the officers or to others in the community? He has a knife. He's going into the store. As an officer, do you want that officer to let him in that store? Have we overcome our serious threat threshold? Is this suspect a serious threat, an immediate serious threat? You make that decision. So now we apply our second standard. Would a reasonable officer facing the same set of circumstances, with the same knowledge of these officers, use the same amount of force? So before we watch the rest of the tape, what force would you apply? How would you stop this knife-wielding man from going into that occupied store? That's the question police face, and they don't have hours to think about how to respond. They have to do it in a second. Again, this is what the jury, who's going to be judging these officers' actions, will have to decide.
They gonna shoot him. No, we got to wait. We got to wait. No, but he got a knife. Get on the ground. They tasing him. He's not even doing nothing. He gonna stab. Oh my God! Oh my God!
And here are a couple of questions that will aid you in coming to a resolution. Was the suspect armed? Did the suspect pose a violent threat to the people in the stores? Should the police have even stopped the suspect from going into the store, right? That's a question. And if you believe the police should have stopped this suspect from going into that store with that weapon, then how much force should they use to stop him? Now, if you are so inclined, let me know in the comment section how you believe this first case should resolve. Should these officers be charged? Or is this a clean shoot? I have the questions, you have the answers. Now let's look at the case of Jacob Blake. Understanding the law and understanding the policy, we now go to the facts.
This graphic video posted on Facebook shows the moment an encounter between Jacob Blake and Kenosha police quickly escalated.
Mr. Blake had just been wrestling with police before that. And the police now are following him around the car. They have guns drawn. So this is serious. And they're telling him, stop, put your hands up, don't move. Mr. Blake at this point now opens up the car door and reaches in. Is Mr. Blake a serious threat to the officer or to the members of the community? A man not obeying police commands, reaching into a car while police have guns trained on him. What do you think he's going to go get? What could he be reaching for?
Hey, sir. 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 Hey.
And I think this is the soul-searching part that most people don't want to assess. Was this man a threat to these officers by this action under these circumstances? If you were the officer and you saw him reaching, what would you think? You had just been wrestling with him. Would you think that he was going for his ID? Or would you think he was going for a weapon? Mr. Blake was not responding to police orders, right? To show his hands and stop. Guns were pointed at Mr. Blake. Mr. Blake was just fighting with the police officers earlier. And Mr. Blake's children were in the car. The key point of this whole thing is Mr. Blake opens the car door and reaches in. That's the key point that we can't ignore. Does that satisfy the standard in Tennessee v. Garner? That's your question. That's a question you have to resolve. Now, if you believe Mr. Blake's actions of reaching into the car to get an unknown object to the officers in this situation pose a significant threat to the officers, then you have a second question you have to resolve, right? Because that's just the first part of our analysis. The second question is, was the force used objectively reasonable? Meaning, would a reasonable officer facing the same set of circumstances with the same knowledge of this officer use this amount of force? Think about it. Are you going to let him pull out whatever he's reaching for in the car to show it to you? And you only have seconds to resolve this. It's not an easy question. So again, like earlier, you have to decide based on the constitutional standards laid forth by the Supreme Court whether these officers are justified or not. Now, I do have a couple of caveats I need to mention. State laws are different, so state laws can be more restrictive, and these officers may be prosecuted for crimes under state law. But we're looking at the federal standard. This standard applies to all law enforcement in all 50 states. And as you can see, it's something that is used all the time. Now, I do want to address, the first is the race issue. Obviously, it is a fact that black people or minorities in the United States are treated differently when it comes to law enforcement experiences. It's just, that is a fact. Now, if people are saying there is no evidence of that, there is no statistics that show that, they are lying to you. They are lying to you. There are many, many, many statistics that I am aware of that show this fact. There's the Stanford study. There's a study here in New York for stop and frisk and for summonses and arrests. There are studies all over the country. Ferguson, for instance. There is no doubt within all law enforcement circles that there is a disproportionate effect. Minorities are treated differently than white people. That is a fact of life. Why is this the case? Well, there's a long history about how black people have been treated, why they've been treated this way, and the history of America, which is one of racism. Think about this. In New York City, one of the most liberal cities in the country, 40% of the police department here happen to be a minority. In this city, though, it was so bad where for marijuana arrests, there was a survey done by the city, and the city found there were just as many white people stopped for marijuana as they were black people, and that the use of marijuana was almost identical in both groups. But if you were black, you were something like 7 times more likely to be arrested and summoned for marijuana use if caught by the police than if you were white. And the reason why is because if white people were caught, they were more likely to be let go with the warning from police. And if a black person was caught, they were more likely to be summoned. Now, just that little change in the law, the discretion of the actual officer, letting a Caucasian person go with the warning versus having a black or Latino person get summons, that little bit of fact, that simple choice made by black and white officers across the board showed that almost 90% of the people who are being arrested and summoned for marijuana violations happen to be a minority. 10% happen to be white, even though both groups were using the illicit drug at the same rates, having the same amount of police contacts for using the drug. That's what institutional racism looks like. That is what we have to overcome.
Government studies show time and time again that whites smoke more pot, or at least they use it more often than other ethnic groups. And there are more whites in New York City than any other ethnic group, yet 84% of those arrested on our streets for marijuana use are black or Latino. This does not add up. This is a policy that overwhelmingly targets people of color. We must acknowledge that racial profiling is an integral part of policing in New York City. Our government leaders, the mayor, the police commissioner, the city council, must acknowledge that it's going on if we're going to be able to put an end to racial profiling and eliminate the toxic effects of racial profiling on our justice system.
Now, I know you're going to have people out there saying that there is no evidence of institutional racism today. Those people are either lying to you or being dishonest. Now, I've said that to say this. This situation with Mr. Blake, I don't believe is one of them. Now, if you want to argue about whether the police should have responded the way they did, whether he was an actual threat, those I think are legitimate questions. Or the question of, well, how come this happens to African Americans at a disproportionate rate? That's a conversation I think you should be willing to have. But for this particular incident, just to say that race had this overarching part in this incident, it's just hard for me to swallow. And I understand the need to boycott. I understand the need to social justice and social change. But I don't think this is the case to make that argument for. I just don't. Trayvon Martin, yes. Walter Scott, yes. George Floyd, obviously. Ahmaud Arbery, yes. This case, I'm just not there. Now, before I end this, I have to say one thing. You made it to this part of the video and haven't subscribed to the channel yet? Like, really? Are you really here listening to me monologue at the end and have not subscribed to the channel? Because if you haven't, you're missing great content like this. So please, click that subscribe button and click the bell so you can know when I upload new videos. Now, again, the only way I can make this type of video, going into this great depth about both the law and these police interactions, is through viewer support, channel memberships, Patreon, PayPal. All the links are in the description. You know where to find them. That's the only way I can bring you this type of content. Without that, then I got to go back to bubblegum and not really delving into these issues. And I want to say one last thing before I get out of here. If you disagree with me, let me know in the comment section. If you agree with me, let me know in the comment section. I try to read every comment. Sometimes I don't get to them all. Let me know how you came out from both cases. Trey Ford Pellerin, 31 from Louisiana, and Jacob Blake. Do you think police were justified in both? Do you think police were justified in one and not the other? Remember, you're the jury. Now it's time for your verdict. My name is Nate the Lawyer. Peace.